Hi there. So the next topic is about employees who says they are scared to speak out because they get victimized and they're scared of losing their jobs and everything. So please tell us more about that, Skulk.
Yes, employees must remember something. The employment laws in South Africa, and especially those that were written post 1996, in other words, after 1996, were designed to protect employees. You have a host of legislation protecting you. You have the Labour Relations Act, you have the Basic Conditions of Employment Act, you have the Employment Equity Act, you have certain ministerial determinations. I can go on and on and on and on. You protected by law. There's a very good reason why. The government of today mostly came out of the left of the political spectrum, mostly from trade unions. The trade union COSATU is part of the ANC tripartite alliance, and therefore the legislation was written in such a way to protect employees. To my opinion, overprotect employees. I am a consultant also for employers. I also assist employers, and I know how difficult it is for an employer to dismiss, for instance, an employee from the workplace. So you as an employee, please do not believe that you are in a weak position in your workplace. You are actually in the best position, the strongest position that you will find anywhere else on earth. Literally, and I mean this. Our legislation is based on legislation that originated in Canada, and that came from, to a large extent, from China. Believe it or not, you can go and fact check me on this. So legislation in the workplace protects you as an employee, not the opposite. If the employer victimizes against you, you have a host of options, amongst others, going to the Department of Labour, of joining a trade union, of lodging grievances, of going to CCMA, etc., etc. There are a host of very good attorneys specializing in labor law across South Africa. If you go to skalkvandermerwe.com, in the very near future, we will start having discussions and podcasting with very, very, very highly trained and experienced attorneys and advocates in labor law. You will also have the way and means to contact them. So yes, if there's any victimization of yourself in the workplace, you need to speak up, you need to stand up, grow a backbone. You have rights as an employee, being entrenched in legislation, and it gives you so much power. It makes you so strong in the workplace. So please do not be scared of a tyrannical employer. Employers, I have a very soft spot for you. I will never go after you or make trouble for you if you do what the law requires of you. But if you overstep the bounds of law, you will be acted against. It's as simple as that. And it will be a harsh punishment for you that will come your way. Why? Because we do not need to be tyrants in the workplace. We do not need to step on the human rights of employees. There's no reason for it. It's simply also counterproductive. We simply don't do that. It's the year 2022. We really passed the point 150 years, 200 years ago, where people were seen, employees were seen as slaves to the employer. We are really not there anymore. We will not allow it. It's as simple as that.
Sure. And yeah, most of people ask, how are we going to fight this thing? Well, you have to fight this. Even though you're scared, you can say something. You can say that you don't want the jab, because an employer can't just let you go. It doesn't work like that. So say whatever you want to say and use your human rights. Just do it.
Yeah, it's ironic that most corporates in the counseling session after the exemption process, tells employees the following. They say that if you do not comply with the policy, then we will dismiss you. Now that is preempted dismissal. Go to any good lawyer, that being an attorney, advocate or consultant, commissioner at CCMA, labour court judge if you have access to somebody in such a position, and ask them what happens if a dismissal of an employee is planned or preempted. In other words, it's decided before the disciplinary inquiry or before the incapacity hearing that an employee will be dismissed. Go and ask what happens at CCMA or Labour Court with such an employer. I can tell you what happens. You will be found to have unfairly dismissed your employee, and your employee will either be reinstated, reemployed, or a harsh amount, a big amount of compensation will be granted in favour of the employee. We call it an award. And if you do not want to pay the award, we simply send the sheriff and they'll go and attach something in your workplace. It's as simple as that, guys. It is really as simple as that. So please, do not overstep the line. Do not threaten your employee with dismissal even before you start with a process. It's unlawful, it's unfair in its very nature the moment that you do it. Full stop. I don't even have to discuss it any further. Leonie.
And to the employees, just remember your company's policy is not the law. If it's not in line with the law, you don't have to adhere to it. As simple as that.
Yes, in that case, you raise a grievance. In your grievance, you write to your employer, Mr. Employer, according to the law, and I want you to go and join up with the trade union or contact me on skalkvandermerwe.com and see who you can utilize if I'm not available. But then you write a grievance to your employer and you say to him, Mr. Employer, you are now transgressing the law. You are not allowed to do that. Your policy is against law. I'm not even speaking here only of COVID. I'm speaking of all policies in the workplace. I am not going to follow it. I'm not being insubordinate when I do this. This is not misconduct, but I cannot be expected to do something that is against law. And you cannot be touched. They cannot victimize you. They cannot charge you disciplinary. I cannot drag you before any hearing because of that.
No. All right. Thank you, Skalk.
That's it.
All right.
Thank you, Leonie.